Stopping by, John. We certainly do appreciate it.
Oh, good morning, Gordy. Thanks for having me.
Yeah, not a problem. Last time you were here, we thought we'd try and tackle the plea bargain issue because, well, I think it gets a little bit of a negative rap, don't you think?
Well, it does in a sense because I think people think that means somebody's getting away with something or they're getting off. But, you know, in reality, a lot of what we do is just it's a balancing test. You know, we have a lot of duties, a lot of obligations that we have to balance when we're looking at what's the right result for a situation. Uh, you have to remember that when somebody is convicted of a crime, they have a lot of uh, what we call collateral consequences. A lot of things that happen to them as a result, a lot of things they can't do that might disqualify them from a job in the future, might disqualify them from a lot of opportunities in life. And so that's one of the things we have to weigh in. We also weigh in what is the appropriate result for the victim of the crime. What does the victim want out of all this? And so we talk to the victims, we get their input, we see what they want to do. And you know, one of the things we want to be careful of is that we're not re-victimizing someone. And for a lot of person crimes, a lot of crimes where somebody's really been badly injured or hurt or abused in some way, that testimony, that consequence of coming to court and having to testify in open court and tell that story and be cross-examined by a defense attorney, that can be a really hard thing for a lot of people. And we don't want to re-victimize somebody. We don't want to make them suffer twice for the event. So if we can get a consequence for somebody where we have registration requirements, we have probation requirements, we have other obligations that they have to go through, and we've protected the victim, and we've protected society, and we have the public safety looked after by that sentence, then that's an appropriate thing to do, and that's what we always look for when we're trying to resolve a case.
If a victim doesn't agree to the plea bargain, are you obligated to not do the plea bargain?
We are not necessarily obligated not to do that, but we certainly have to advise the court that the victim does not agree. And but we have, I mean, I have in my function, I have a lot of discretion how to handle those cases and what the appropriate resolution should be. And sometimes the victim is not on board, but it's still what the facts would support, what the case law would support, because when we charge out a case, it's not, we don't necessarily have all the facts. We don't necessarily know really what happened. And so sometimes it gets overcharged, sometimes it gets undercharged, and we try to catch up and make sure that we have everything in place. And if witnesses have gone missing, we have to take that into consideration as well. Or people have forgotten stuff.
Yeah, which does happen.
Which does happen.
Yeah. We'll talk more about plea bargains and how they came about, how long they've been around. I don't even know if John knows how they came about or how long they've been around, but we'll try and tackle some of those issues when AM Minnesota continues. But first of all, we need to get our opening market. We were just chatting a little bit off the air, John and I. I know it's hard to believe we do that off the air, but we do chat a little bit off the air. John was telling me a very interesting story, and I'll just let him talk about that, because I was asking how plea bargains got their start. They've been around a long time, you were just saying.
They've been around a long time, and as we were talking off air, you know, there's an excellent Rice County context for that, which is, and as I told you, I'm a former president of the Northfield Historical Society. So when the three younger brothers were caught in Medelia after robbing the bank in Northfield, and they were charged with murder in Rice County District Court. And at the time, Minnesota had a death penalty. So in 1876, there was a death penalty. But if they had gone to trial and been convicted, they would have faced the death penalty. However, they chose to enter a plea of guilty and got a sentence of life. And so then they were sentenced to prison up in Stillwater, and as you noted, started the prison newspaper, the Stillwater Mirror, and were eventually paroled in 1900 or so. And initially their conditions of parole were that they could never leave the state of Minnesota. One of the younger brothers and could not get married, And one of the
No
brothers.
kidding, a condition was not to get married?
That's right. And one of the brothers, I think it was Jim, was the handsome one, and he'd found a girlfriend, and because he couldn't get married, he wound up killing himself. And then the conditions of parole for Cole and the other younger brother were that they had to leave the state of Minnesota and never return, and so they went back to Missouri, and Cole went off in the Wild West show.
Oh, wait a minute here. You said Jim Younger took his own life.
Yes.
Because he couldn't be married?
Yes. You're going to get yourself in trouble if you keep talking, Gordy.
No, I'm just curious as to, you know.
Well, depression does funny things to people, and I think that was part of the issue. At least that was the story that I heard. That's why he took his own life.
Huh.
Was that he'd found this woman after he got out of prison that he was fond of, and he wanted to get married, and as a parolee, he was not allowed to get married.
Well, that was an interesting thing for the judge to rule.
And
to not be. I don't understand why you wouldn't want him to be married.
Well, and I think it would have not been a judge. I think it was probably a parole board. That they had probably a parole board, including the governor and some other people. It had been 25 years since they had robbed a bank in Northfield, and they decided that was an appropriate term and condition of release, and it may have been that that's what they did for everybody, because when you're convicted of a crime, as we were talking about earlier, there's a lot of things that you lose. You lose a lot of civil rights as a result of that. Modernly, you lose your right to possess a weapon. You lose your right to vote. You lose a lot of other things. And getting married was one of those rights, one of those collateral consequences at the time, because you were no longer a free person. You were no longer a lawful person, and that was one of those conditions. In Minnesota, we let you vote again after you've gotten off paper. Once you're off probation as a felon, then you can start voting again. But you can't. You still can't possess a gun, depending on the level of crime.
Many people call me in the middle of shows.
It must be important.
I don't think so. You never know, I guess. But I found that very interesting that they would put that as a condition, because you would think, my theory would be, that you'd be more settled down if you marry, and probably would not be as apt to want to rob a bank.
Right, and so they, again, we put all kinds of conditions on people to say, in order to stay out of prison. And like I said, their first condition was they could not leave the state of Minnesota. So they wanted to be able to keep control of them, and they decided, you know what, it'd be better if they weren't here. And then they had to leave the state of Minnesota. So that was all part of the control, I guess, we have over people once they've been convicted of a crime. That you have, you might describe it more as a bundle of rights that you have, right? And so you have a bunch of sticks that are those rights. You have the right to marry, you have the right to vote, you have the right to travel freely, you have the right to hold a job, and we take away some of those sticks once you've been convicted of a crime. Those are the kind of collateral consequences that we were talking about. Once you're convicted of a crime, you can't do that stuff.
Now, according to criminallaw.com, I think that's what it's called, criminal.law.com or something like that, according to that website, overwhelming, these are their words, overwhelming majority of cases end in a plea bargain.
Yeah. And nationally, I think the numbers are 90 to 95% of all of criminal cases are resolved by some kind of plea bargain. Sometimes that means that another case gets dismissed as part of it. Sometimes it's an agreement about sentence. Sometimes it's an agreement about the charge. Sometimes it's an agreement about some combination of all those things based on what goes on. It doesn't necessarily mean that somebody is getting away with a crime. It does mean, the U.S. Supreme Court has had a lot of case law about this in the last several years, and so one of the things that the Supreme Court has told us over and over again is that the crime, or that the sentence, should fit the offender, not just the crime. And so we have to have a sentence that's tailored to fit that person. And plea bargaining becomes part of that process where we agree what is appropriate for that person, what sort of opportunities should they still have in life, what sort of penalties should they suffer as a result of their criminal conduct.
In reality, the court couldn't function without this tool, right?
That's right. We just do not have the resources to try all of those cases. I mean, in my office we have roughly 800 open cases at any one time, criminal cases. And we can try at the Rice County Courthouse. We have 3 judges who sit there, and we have 2 courtrooms that have jury boxes, but there's so many things going on at the courthouse at this point that there are the position of court administration is that they can only have 1 judge in a trial at any one time, and so the reality is that what we can do is try maybe 1 case at a time, and 1 or 2 cases a week, depending if it's a small case, and then you have to factor in that our city attorneys have cases that need to go to trial as well. There are civil cases that need to go to trial as well. There are child protection cases that need to go to trial as well. And when we look at all those things and we have room for 40 or 50 trials a year, and thousands, more than 1,000 cases a year running through that system, and even more than that when we count all of the city cases and the civil cases, there just are not the resources to try all those cases, and we don't expect them all to go to trial anymore.
Which brings a question to mind. You have a right to have a speedy trial, right? That's what they tell you, a right to a speedy trial. Is that defined in any way, shape, or form?
In Minnesota, the criminal rules say that if you are if you demand your right to a speedy trial, you have a right to have that trial within 60 days. If court calendar doesn't allow for that to happen in 60 days, then it's supposed to happen within 60 days at that point. So people have that right to have a speedy trial. If they're in custody on a misdemeanor case, they have a right to demand that their trial happen within 10 days, because we wouldn't want them to sit in jail for 90 days awaiting trial on their case that they could serve a maximum of 90 days in jail on. So there is the right to a speedy trial if you're not in custody. And for the defense, a lot of times they want some time to evaluate the case. They want some time to do a little bit of investigation, and they wouldn't necessarily want the case to hurry up and get to trial.
Now, you are in the nice position, for our purposes, of being a defense attorney at one time and now a prosecuting attorney.
Right.
So you must have, do you have a different viewpoint now as a prosecuting attorney of a plea bargain or is it the same as you had as a defense attorney? I'm just curious.
Well, my idea of what's fair might have changed a little bit. and my former colleagues in the defense bar often tell me they think that I'm being unreasonable. But yeah, so my views have changed a little bit, but I also think that there are things that we need to do. We want to make sure we're protecting public safety, that we're looking after people, and we're protecting the victim. And but I don't have the obligation I had before of looking after my client, which is your obligation as a defense attorney. You have to try and get the best result for your client that you can get. And so, but as a prosecutor, I have to look out for, again, we have a real balancing test. We have to be fair to the defendant, but we have to look out for the victim. We have to look out for public safety, and we have someone who we think is a real public safety risk. Even if they're a public safety risk to only one person, we have to do what's right to protect that person. If they can function in society generally, but there's one person that they just can't deal with and are repeatedly causing problems with, then we have to do something about that. And sometimes that means we're looking for prison.
But as a defense attorney, you also wanted to make sure that people are safe, right?
Right.
Even as a defense attorney.
Even as a defense attorney, but I also had my main obligation was always to my client.
Right.
And now I have 65,000 clients here in Rice County.
Did you explain all of the, because I read a report here that was issued by, I don't know, some social professor, did a study, a sociology professor, there we go. Sociology professor did a study on plea bargains, and they relied on over 600 hours of court observation, during which period of time they followed over 250 cases and interviewed 40 indigent criminal defendants. And they said that by and large they found out that the defendants didn't really understand the whole process.
Well, and I think that can happen. I think that there's a lot that happens in the courtroom, and it can happen pretty quickly, but the function of that defense attorney is to make sure that they've explained it to their client, and that they sit down and go through everything. And I always did that with my clients, and I always told them, if you're not guilty, don't plead guilty. If you didn't do it, let's go to trial, because that was that was my function. Or if you don't like this deal,
then don't agree to it.
Then don't agree to it. And a lot of times they'd say, well, I don't know what to do, and I'd say, well, you've got these two options, and if you don't do anything, we're going to trial, because the only way for you to take this deal is to agree to it. And if you don't agree to it, that's fine. We'll move forward with the process, and you can have your trial, and we'll do the best we can do.
So the bottom line is, the person you're defending has the final say in whether or not a plea bargain happens.
It's absolutely their decision. They do not. The defendant should not be coerced into taking a plea, and that's one of those things we ask in court. Say, has anyone made any threats or promises to get you plead guilty? Are you doing this of your own free will? That's all part of the allocution of the plea. That's all part of the factual basis that we lay. And so people who sit in court and watch that stuff wonder why we're wasting all that time. But we're doing it to make sure that we have, first, a defensible plea, that somebody's going to come back and say, well, I didn't know what was going on. Well, gosh, you said under oath that you did. You said under oath that you understood that you have a right to a trial, you have a right to cross-examine the witnesses, and you have a right to present your case and subpoena witnesses in your defense, and you're giving that all up when you enter this plea of guilty.
The author of this report, Jeanette Fossum, hope I pronounced that right, says defendant decision-making rests on a limited understanding of the procedures and decisions that are involved in the criminal courts. Broadly speaking, defendants support court procedures such as plea bargaining because they feel that the procedure allows them to quickly exit an uncontrollable and confusing situation while receiving the benefit of a more lenient sentence.
Well, and sometimes it's not a more lenient sentence. I mean, sometimes sometimes the only plea bargain is plea discharged guidelines. And really, we offer incentives where we think they're appropriate, but some cases it's not appropriate. And sometimes we'll offer someone a plea bargain, but if they don't take it, then we're going to trial, and we're going to try and prove them guilty, and we're going to try and get the maximum sentence. But for some cases, a plea bargain is just not appropriate. And knowing which those cases are is always is part of the difficult part of what we do.
Well, I'm thinking a heinous crime, obviously. You don't want to plead that out, right?
Right, and there's a lot of pressure to do that. There's a lot of pressure to say, hey, here's a way we could resolve this short of a trial. But sometimes trying cases is what we have to do. So it's, a lot of people lean on and say, well, you shouldn't waste all this time in court. You shouldn't take up all this trial time for this one person. We shouldn't have to call in all these jurors to do this. But our system requires that sometimes we take sometimes there are important things that we have to do, and going to trial is one of those things.
As an attorney, I would guess that you probably enjoy having a trial.
I do. It's a lot of stress. One thing people never understand about trial is that, or about lawyers, is that when you're sitting there in trial, it is a very stressful situation. It's one of the things that makes it hard, you know, for people to be lawyers because, or trial lawyers, because you're in that constant situation of fight or flight while the trial is going on. So for those hours that you're sitting there, you have to pay attention to everything that goes on. You can't let your mind wander for a second because something's going to happen. You have a second to stand up and say objection,
right,
and here's my reason for doing it. And you have, you know, you have a few seconds to respond to somebody else's objection or argument as to why something should have happened or shouldn't have happened or should be said or shouldn't be said. And the judge is in the same situation. They have to sit there and pay attention and be awake throughout the whole thing and not miss things and not have somebody say objection and say, I'm sorry, what happened? Right? So it's a very exhausting thing to be in trial, to sit there all day, and people don't understand that because they think you're just sitting there. But it really is hard work because there's a lot of stress, there's a lot of effort put into paying attention so that you don't make it, so you don't mess up.
So that's added stress, as you said.
Yeah.
That's why some attorneys don't even go into criminal law, because they just as soon not be in the courtroom.
And that's why some attorneys do anything they could do to avoid trial. But at the end of the day, you're exhausted, you're worn out, and at the end of the case, you're tired and you're worn out, and the next week you get up and you do it again.
But the chess match,
mm-hmm.
for lack of a better term, the chess match of the trial, I would think would be, you know, pretty exciting.
It certainly is, and you know, trial strategy and planning is very important. Making sure you have everything lined up, and frankly, it's a more complex thing from this side than from the other side.
Oh, it is.
As a defense attorney, you can sort of try and poke holes in the prosecution's case, and as the prosecutor, you have to find the whole proof way of presenting your evidence, and make sure you have everything planned out carefully and intelligently. And so, yeah, that from that standpoint, it really is a chess match.
Did you think that was true when you were a defense attorney?
I always respected the work of the other side, and good lawyers who do good work on both sides, and so it's probably more difficult than I would have thought it was, but I also understood that people were working hard and doing good jobs. So I've had some really good trials with some really good lawyers.
I understand it's hard these days to find public defenders. Is that true?
I don't know about that. I know when we had an opening in our office, we had 60 people apply for it.
Oh,
so
okay.
I think that they had a number of openings in the public defender's office, and I think they had a number of people ready to fill them. I think there's an awful lot of young lawyers out there looking for work.
I remember years ago, many years ago, shortly after I first arrived in town, and I won't say who it was, but a local attorney who was a public defender decided he was no longer going to be a public defender. And the reason he decided that, he said, is you just don't make enough money.
Well, and there's different levels of public defense, and the public defender system has changed quite a bit over the years. Initially, there were county appointments, and so the county would pay the public defenders, yep, and the judges would appoint, and the lawyers would get paid either a flat fee per case, or they would get paid an hourly rate. And then, about 25 years ago, the state took over the public defender system statewide, and instead of having county-based or district-based systems, it's now a statewide system, and the public defenders aren't working on a flat fee. They aren't working on an hourly rate. They get paid a salary, and they get benefits and opportunities, and a lot of them are part-time, because if they had all the public defenders working in one full-time office, they'd have a conflict every time there was more than one defendant in a case, and they'd have to hire somebody else to do it. So they have a lot of part-time public defenders, particularly in this area, who handle the cases that don't go to the full-time office, but then there's full-time lawyers, and for a lot of them it's a career. It's something they really enjoy doing, and a lot of public defenders after a while move on to do something else, like I did about 12 years ago.
Well, thanks, John. Certainly appreciate your stopping in. Hopefully people got a little bit of a better understanding about why we have plea bargains. Because in reality, we wouldn't be able to try all these cases without it.
That's true, and thanks again for your inviting me over, Gordy.
Yeah, I certainly appreciate it very much. We'll have to think of a topic for next time.
Well, we got some time, don't we?
Yeah, so we'll think of something.
Okay, thank you.
We'll have John in studio again next month. Certainly appreciate his agreeing to be with us on a monthly basis here. As I mentioned before, I don't know who Jerry's going to have on the program tomorrow. I do know that next Tuesday, John Dvorak will be back in studio to talk about the Rice County Fair, which is hard to believe, but it's not that far off when you really think about it. Dr. Annette Parker, president of South Central College, is scheduled to be with me 1 week from today, next Monday. Dr. Parker will be with us. Haven't had a nice visit with her in a while, so we're looking forward to that. And this Friday, North Johnson, the Faribault Chamber, and Todd Markman will be in studio. That concludes today's edition of AM Minnesota here on KDHL-AM in Faribault, Minnesota. Get out and enjoy the day. It's a bit cloudy, and they're talking about every kind of weather imaginable this week, from sleet